The doctrine of res judicata gives finality and reliability to judicial decisions. Claims already decided can't be tried again. The 1986 case of Car Carriers Incorporated versus Ford Motor Company sets the record straight on what happens when the facts underlying a new claim have already been litigated. Car Carriers Incorporated was a transport company that moved Ford vehicles from Ford's plants around the Chicago area. In 1975, Ford gave Car Carriers directions to sell their entire business to another Ford carrier called E&L. Car Carriers negotiated with E&L, but Ford interfered and prevented an agreement from being reached. A couple of years later, Ford induced Car Carriers to spend over $6 million on new equipment. Ford promised that Car Carriers would make up the costs. However, Ford interfered with the rates Car Carriers was subject to, keeping them from being profitable. Soon after, Car Carriers tried to acquire the outstanding stock of another Ford carrier to consolidate and reduce costs. However, Ford closed the other carrier and moved the remaining contracts to E&L and the carrier New Car. A few years later, Ford terminated Car Carriers and moved their contracts to New Car. Car Carriers attempted to reduce losses by selling their assets to New Car, but Ford and New Car barred this. Car Carriers thought the treatment they'd received from Ford was part of a pattern Ford used in a conspiracy with certain carriers to eliminate other carriers. This pattern started with Ford forcing targeted carriers to make giant investments and then keeping the carriers from getting the rate increases the carriers needed to stay profitable. Then Ford would keep the unprofitable carriers from being able to merge or sell their companies. Once this happened, Ford would terminate their contract with the carriers and let their co-conspirator carriers acquire the targeted carriers. Car Carriers and 6 other transport companies sued Ford and New Car in federal court under the Sherman Act and 5 pendent state law claims. The district court dismissed the case with prejudice. Car Carriers appealed, and a 7th Circuit panel affirmed the dismissal. Car Carriers then filed a new complaint in federal court, with a mix of 24 federal and state claims. The district court dismissed this case too. The federal claims were barred by res judicata, and the state law claims were dismissed for lack of pendent jurisdiction. Car Carriers appealed to the 7th Circuit again.